Hi, I'm Regina Taylor, a Gastonia, North Carolina bankruptcy attorney, and I wanted to talk to you today about what happens when a creditor or someone that you owe sues you. The creditor might be a credit card company, it may be your car loan company, or just anyone in general, a private person or a finance company that you've borrowed money from. The first thing that happens is you will probably have gotten a number of telephone calls from the creditor trying to collect on the debt. Let's say years have passed or even months and the creditor has stopped their collection activities, and suddenly the sheriff or process server appears at your door and serves what's called a civil summons on you. That civil summons, the first thing that you should notice is it will tell you that you have a certain time period that you can or should respond to the creditor's lawsuit. Okay? You must do something. One of the biggest mistakes that most people make is that they ignore it. They do nothing. You may say, well, yeah, I do owe money, but there's nothing I can do about it. You may feel defeated. But there may be some defenses that you have to this debt, okay? And what you need to do is you need to contact an attorney, either someone that you retain. If you don't have the funds to hire an attorney, you may be able to seek the help of legal services or legal aid to help you. Once you visit your attorney, please remember to take those papers with you. You should note when you were served by the sheriff. If the sheriff didn't serve you and you were served by certified mail, you should let your attorney know the certified mail date. Or at the worst case, take the envelope that you received the papers in to your attorney. He or she can then find out what the date of service was. That date is important because it starts the clock ticking as to when they must or you must file a response with the court. One of the worst things, I'll repeat again, that you can do is to do absolutely nothing and totally ignore it. If you totally ignore it and do absolutely nothing, then what the creditor may do is file a motion with the court to get what's called a default judgment. And that just says that you, the debtor or the defendant in the action, did nothing, and then they can ask the court to grant them whatever they want. If you look at the papers you've been served, the creditor may be asking for the initial amount of the debt plus any accrued late fees, interest, over limit fees that may be owed. And at that point, the amount that you owe has just increased tremendously. Okay? If you go to your attorney first, your attorney will file a response. They may be able to negotiate a settlement with the creditor. If a judgment is entered against you here in North Carolina and in many states, the judgment becomes a lien against any real estate that you may own in that state. If you don't own any real estate, then what the creditor may be able to do is when they attempt to execute that judgment, they may be able to take any personal property or household furniture or other items or your bank account that you may own. So it's really important not to do anything else. Excuse me, it's really important to do something else. If you have any questions, please send me your questions below. I will respond. Or you may contact my office at 704-861-0700 or toll free at 866-501-2098, or you can visit us on the internet at www.attorneyreginataylor.com. Thank you.